morning, everybody, and welcome to our in-house lawyers webinar. My name's Caroline Benfield. I am a director in the restructuring and insolvency team at Freeth, and I'm joined today by my colleague Elizabeth Taylor, who's also a director in our restructuring and insolvency team. We've worked together for many, many years and have combined over 50 years experience of matters relating to personal and corporate, contentious and non-contentious insolvency. And that means that we don't just deal with contentious matters. We also advise and act in relation to restructuring, sales of businesses and assets in the context of administrations, and all other ancillary matters that might arise in the context of assisting businesses through financial difficulties and insolvency processes. We're going to be speaking to you today about some of the more salient corporate insolvency processes and some key aspects that may be of interest to you, including retention of title, the position of secured and unsecured creditors in an insolvency process, and directors' duties in the context of an insolvency situation. At the end, I'm going to take you through some of the recently released statistics for 2024, what we saw in terms of numbers of insolvencies last year, and what we anticipate might happen this year, because those statistics very much highlight why it's important to be alive to the problems that businesses face, the options available to business owners, and the importance of taking timely advice from the right professionals. Now, at the bottom of your page, you'll see a Q&A button. If you do have any questions for us, then please do pop those into the Q&A. We do have quite a lot to cover today, so we may not get to everybody's questions. And if that's the case, as long as you've put your name into the box when you've entered your question, what we'll do is we will contact you directly after today's session. So I'm now going to hand over to Liz, who's going to look at some of the more salient corporate insolvency processes. Thanks, Liz.
Thanks, Caroline, and good morning, everybody. So looking at corporate insolvency procedures, these can broadly be divided into two classes. The first are procedures which are designed for or contemplate or allow the rescue of the company as a going concern. And secondly, those that are concerned only with the ending of any ongoing business, the realisation of assets, and the return of any monies obtained from that process to creditors. All of these processes require the appointment of a licensed insolvency practitioner. So the corporate insolvency procedures, which are capable of allowing the survival of an insolvent company or its business, are administration and company voluntary arrangements. So first of all, we'll have a look at administration. Administration is a procedure whereby a company is given a breathing space under the protection of a statutory moratorium on creditor action to allow it to be rescued or reorganised or its assets realised. And we'll look at the moratorium in more detail later in this talk. So administration can be instigated by an application to court for an administration order by the company, the directors, or a creditor. And the court will make the order if it's satisfied that the company is insolvent and that one of three statutory purposes can be achieved. And we'll look at those purposes in a moment. A detailed report from the proposed administrator must be produced containing comprehensive financial information. So in reality, it can be difficult for a creditor to make the application because they're unlikely to have access to sufficient financial information. And because of the level of detail required in the report, it's also a very expensive process. But administration under this process will commence when the administration order is made. More common is the commencement of administration using an out-of-court appointment by the company, the directors, or the holder of a qualifying floating charge. So a QFC is defined in the legislation to mean a charge over all or substantially all of the company's assets. And importantly, a qualifying floating charge holder can appoint administrators even if the company is not insolvent where an event of default as defined in the security documents has occurred. In this scenario, administration commences when the appointment documents are filed at court. Once a company is in administration, the director's powers come to an end and all of the assets of the company come under the control of the administrator. Even where they're appointed by a charge holder, the administrators must then perform their functions in the interest of all of the company's creditors, not just the secured creditor who appointed them. So looking at the three statutory purposes, as part of the appointment process, the administrator must set out which of three purposes, the three statutory purposes he believes is achievable. And these are, firstly, rescuing the company as a going concern, and that's not the same as the company's business. So this is rarely used because it's very rare to be able to rescue the company as a going concern. So if that's not an option, then the administrator will consider the second purpose, which is achieving a better result for creditors than would be achieved in a winding up. And if that isn't likely to be possible, the third purpose is realizing property in order to make a return to one or more secured or preferential creditors. The administrator must then produce proposals and put these to creditors for approval within 8 weeks of commencement. And these will show which statutory purpose he proposes to achieve and how he intends to achieve it. So the moratorium, and this is a really important aspect of administration, this comes into effect when an administration application is filed with the court or when notice of appointment is filed at court using the out-of-court procedure. Where an out-of-court appointment is to be made by the directors or the company, notice of intention to appoint must first be given to the holder of a qualifying floating charge, who then has an opportunity to make their own appointment. So where an out-of-court appointment is to be made by a second or subsequent charge holder, notice of intention must be given to prior charge holders. So in both cases, the notice of appointment, the notice of intention must be filed at court, and the moratorium begins at this earlier point in time. So the main effects of the moratorium are that no security may be enforced without the consent of the administrator or permission of the court. So it's a very draconian step. And this includes retention of title and hire purchase creditors who may not recover their goods. And I'm going to talk in more detail about retention of title later in this talk. A landlord may not forfeit the company's lease without the consent of the administrator or the permission of the court, but the administrator is required to pay rent for the period that he occupies the premises for the benefit of the administration. No other insolvency proceedings or any other proceedings can be commenced or proceeded with during the moratorium. So if the administrator refuses permission to act contrary to the moratorium, the party seeking to enforce its rights can make an application to court for permission. And the court then has to undertake a balancing exercise between the proprietary rights of the applicant and the interest of the creditors as a whole. And permission will only be granted if doing so will not affect the administrator's ability to satisfy the statutory purpose of the administration. So the administrator has power to trade the company, so he can take over the running of the company and its business in order to achieve one of the statutory purposes which he thinks capable of achieving and in accordance with the proposals. And in these circumstances, all the business documents and the company's website must state that the company is in administration. Typically, the administrator will sell the company's business and assets, and thereafter the company will be put into liquidation or dissolved. But occasionally, a company can be rescued through this process, although it's rare, but we'll come on in a moment to look at an example of where that can happen. A pre-pack administration, and that's short for pre-packaged, is not a term that appears anywhere in the legislation, but this is a process whereby a purchaser is found for the business or the assets of a company before the company is placed into administration. The terms are agreed between the proposed administrator and the purchaser, and sale documentation is finalised. And only at that point, the company is placed into administration, and immediately thereafter, the sale is completed. This process is useful where there's a risk that administration will lead to a reduction in the value of the goodwill and the loss of key staff once the existence of the administration becomes known. It has been subject to criticism and concern that if assets are not widely marketed, best price is unlikely to be achieved, especially where the purchaser is a connected entity. However, the administrator is required to demonstrate that he has achieved the best price for the assets, which may not always be the highest price. So, for example, if you compare an offer to pay £100,000 up front with an offer to pay £150,000 payable by instalments over a period of months or years, the administrator may decide that the lump sum of £100,000 is better than £150,000 payable by instalments if he's got doubts over the purchaser's ability to maintain the payments. So where there is a pre-pack to a connected party, the purchaser is required to obtain a report from an independent evaluator who is a professional person with relevant experience. And the evaluator will then prepare a report to confirm whether the proposed sale is fair and reasonable. So there are protections in place. An administration will end automatically after 1 year unless its term is extended before its expiry date. Creditors can resolve to extend the administration for up to 1 year, but thereafter only the court can grant further extensions. Extensions are typically required where assets have not yet been sold, such as property, or work in progress has not been collected, or contracts have not been completed. And there are valid reasons why an alternative insolvency process is unsuitable. So that's administrations. And the next rescue process I'm going to talk about is company voluntary arrangements, or CVAs. A company voluntary arrangement is a statutory contract which is intended to assist in the rescue of a company in financial difficulties. And it's likely to be the most suitable solution for those directors who wish to retain control of the company and attempt to trade out of the difficulties. It amounts to a contract between the company and its creditors to satisfy some or in some cases all of the debts, and it's implemented and supervised by an insolvency practitioner. Proposals are drawn up and put to members and creditors who must approve them. Both categories must approve the proposals. And this requires a simple majority of the shareholders and 70% by value of creditors attending and voting. The proposals must include details of all the company's assets and liabilities and the company's proposals for payment, either by way of a lump sum or monthly contributions over a period of months or years. A supervisor is appointed, and his role is to monitor compliance with the arrangement, to receive the payments, and to distribute them amongst the creditors. A CVA can be used to avoid or to supplement other types of insolvency processes, and it may be used in conjunction with administration, where the moratorium gives the company a breathing space to agree proposals with creditors. And this is an example of where administration can result in the survival of the company. A CVA becomes binding on all unsecured creditors if and when it's approved by the creditors. And once bound by a CVA, a creditor is prevented from taking steps to enforce any of its rights against the company that would be prohibited by the CVA. And so the effects of a CVA include that the proposals bind all creditors, including untraced creditors who would have been entitled to vote if they had not received notice. The company's assets remain under the control of the directors of the company, unlike in administration. But a supervisor may petition for a winding up order, which we're about to come on to, if the company defaults in complying with its obligations under the arrangement. Creditors can challenge CVA on grounds of material irregularity in the process. For example, if they think that votes have been miscounted, or creditors have been deliberately omitted and not received notice, or on grounds that the proposals are unfairly prejudicial to the applicant. And such challenge must be made within 28 days of approval. So those are the two rescue processes. Next, I'm going to come on to talk about the liquidation, which is effectively concerned only with the cessation of ongoing business. So liquidation brings the business to an end, termination of all staff and commercial contracts, and then assets are realised and returned to creditors through the payment of a dividend. And at that point, the company is dissolved. Now, there are two types of liquidation. The first is compulsory liquidation. This is a court process which is commenced by the presentation of a winding up petition by a creditor, the directors, or the company itself on grounds that the company is unable to pay its debts. A petition can also be presented by a CVA supervisor if the company fails to comply with the terms of the CVA. The court makes a winding up order and the official receiver becomes liquidator. The official receiver can appoint an insolvency practitioner to take over as liquidator, or creditors can requisition a meeting to appoint a liquidator. But through this process, the company and the directors will have no say in the appointment of the liquidator. So voluntary liquidation, there are two types of voluntary liquidation. This is an out-of-court process commenced by a company resolution. The first type of voluntary liquidation is a members' voluntary liquidation. And this is appropriate where the directors are able to give a statutory declaration of solvency to the effect that the company will be able to pay all of its debts in full within 12 months. And this process is used typically to close down a solvent business or as part of a group reorganisation. Asset proceeds are returned to shareholders, or the assets themselves are transferred to the shareholders. The second type of voluntary liquidation is a creditor's voluntary liquidation. And this is appropriate where the company is insolvent, and so the directors cannot give the statutory declaration of solvency. This can be a more attractive option for companies than a compulsory liquidation because the company will have a say in the choice of liquidator. But it will only be possible if an insolvency practitioner agrees to be appointed, which will usually only be the case if the IP is satisfied that the company has sufficient assets to cover payment of his fees. If there won't be sufficient asset realizations to cover the IP's fees, then the company or the directors will have to resort to the presentation of a petition to have the company wound up compulsorily. The company in a CVL, a creditor's voluntary liquidation, approves the appointment of a liquidator, and then creditors are asked to vote on the appointment of the liquidator when they can either ratify the company's choice or they can appoint their own liquidator. And a solvent liquidation will be converted into a creditor's voluntary liquidation if it transpires down the line that creditors are not all going to be paid within 12 months. So to summarise the effects of all types of liquidation, the business ceases, all staff will be made redundant, all contracts will come to an end, the powers of the directors will cease and the liquidator will take control, and the liquidator will collect assets and distribute them in the prescribed order as set out in the Insolvency Act, and Caroline will come on to talk about that later on. And a liquidator, he has very wide powers to realise companies' assets, including the power to disclaim any onerous property. So next, we're going to look at LPA or fixed charge receivership. So an LPA receiver or a fixed charge receiver is appointed by a secured creditor using powers set out in the Law of Property Act. So there's a difference between an LPA receiver and a fixed charge receiver. So an LPA receiver is appointed under the Law of Property Act. A fixed charge receiver is appointed by a secured creditor using powers set out in the charge document. And those will normally augment the powers that are set out in the LPA. Receivership is not technically an insolvency process for the benefit of all creditors, as is the case with administration, CVAs, and liquidation. It's a method of enforcing security. A receiver is an individual appointed by a creditor who holds a charge over the assets of a borrower to take custody of the charged assets, to manage those assets, and to receive the income from them. Usually, a charge document will give the receiver the power to sell the assets and apply the proceeds of sale in satisfaction of the secured debt. But if there is no power of sale, and that would be unusual but not unheard of, the receiver's role is to receive the income from the property and apply it against the secured debt. Unlike a liquidator administrator or a CVA supervisor, a fixed charge receiver is not an insolvency office holder for the purpose of the Insolvency Act and does not have to be a licensed insolvency practitioner, and he is not an officer of the court. A fixed charge receiver is appointed by a lender but acts as agent for the borrower. They owe a duty of care to the borrower and any guarantor of liabilities secured by the charge, and so they must not dispose of assets at an undervalue. The principal duty of a receiver is to preserve and realise assets over which they're appointed in order to repay the liabilities of the borrower secured by the charge. The process of appointing a fixed charge receiver is governed by the terms of the charge document to the extent that these displace the provisions of the LPA 1925. Essentially, it's simply a case of the charge holder giving written notice to the proposed receiver and the receiver accepting the appointment by the end of the next business day. The date of the appointment is the date that the notice was received by the receiver and not the date that the receivers confirm their acceptance. Typically, most charge documents provide that a charge holder can appoint a receiver when the security becomes enforceable, which is usually when an event of default occurs as defined in the charge document. The appointment of a receiver displaces the director's powers of management, but only over the assets which are subject to the receivership. A receivership appointment does not remove the directors from office, and so the directors can continue to exercise their residual powers in areas that are unaffected by the receivership. Technically, it is possible for the company to survive receivership, but this is unusual, especially where the receivers have a power of sale, because the company is unlikely to be able to trade once the charged assets have been sold, and it will therefore typically go into liquidation. There is often overlap between receivership and other insolvency processes. So we'll just have a quick look at those. So the moratorium in administration prevents the appointment of a receiver following the commencement of the administration. Where an administration order is made, a receiver who is already in office must vacate office. And where administrators are appointed using the out-of-court process, the administrators can require the receivers to vacate. A charge holder can still appoint a receiver to the assets of a company after it's gone into liquidation, although there is some uncertainty as to whether in the case of a compulsory liquidation, permission from the court would be required under Section 130 of the Insolvency Act, which prohibits any action or proceeding against the assets of a company without leave of the court. A receiver in office prior to the commencement of liquidation can remain in office, but will no longer be the agent of the borrower. And depending on the wording of the charge document, the receiver will either continue to act as principal or as agent for the charge holder. There will be a risk of duplication of costs and therefore reduced funds available to unsecured creditors where a receiver and a liquidator are in office simultaneously. But a charge holder is entitled to protect its commercial interests and does not owe any duty to unsecured creditors when considering whether to make the appointment. So those are the main insolvency processes that you'll come across. There are some lesser used processes that were introduced into the Corporate Insolvency and Governance Act 2020, but they're currently quite rarely used, and I'm not going to cover those today. But if anybody's got any queries on those, do pop them in the Q&A, and if we've got time, we can look at those later. So next, I'm going to talk about retention of title. The purpose of a retention of title clause is to give a seller priority over secured and unsecured creditors if the buyer fails to pay for the goods. This can be very important if the buyer enters a formal insolvency process. A basic retention of title clause provides that title to goods remains with the seller until they have been paid for. It's essential to ensure that the seller's contractual terms are incorporated into the contract. The last set of terms provided or referred to where terms and conditions are stated to be available on a website will be deemed incorporated into the contract. If the last set of terms and conditions are the buyer's, these will typically include a provision stating that title to the goods supplied passes on delivery, which is obviously not what the seller would want. Contractual terms printed on an invoice, which we often see, are post-contractual, and therefore they will not form part of the contract. A basic retention of title clause should contain the following rights in favour of the seller. A right for the seller to enter the buyer's premises to repossess the goods in defined circumstances, and a right for the seller to prevent the buyer from selling or using the goods in defined circumstances. It should also include the following obligations on the part of the buyer, which are the obligation to store the seller's goods separately from the goods belonging to other third parties, an obligation to mark them clearly as the seller's property, and to allow the seller access to the buyer's premises to verify that this has been done. An all monies retention of title clause is a slightly different type of clause, and this states that no title to goods will remain with the title to all the goods will remain with the seller until all sums due to the seller have been paid. So not just the goods supplied pursuant to a particular invoice, but all goods. The advantage of such a clause is that unlike the position with a basic retention of title clause, it negates the need for the seller to relate specific goods at the buyer's premises to specific invoices. But there is a debate about whether an all monies retention of title clause creates a charge by the buyer in favour of the seller over the goods, which would be void against the liquidator or an administrator for lack of registration. So this is a complex area and beyond the scope of this presentation, but the position will depend upon the drafting of the clause, and to be effective, title to the goods will have to pass to the buyer, and that would be inconsistent with a desire on the part of the seller to retain ownership. Some retention of title clauses allow the buyer to sell the goods on before they've been paid for and purport to enable the seller to assert rights over the sale proceeds. The courts have held that such a clause does create a charge in favour of the seller, which would be void against the liquidator or administrator for want of registration. For a basic retention of title clause to be effective, the goods must retain their original identity. A basic retention of title clause will therefore be ineffective if the goods have been mixed with other goods as part of the manufacturing process. Where goods have been incorporated into a product but can be easily removed without causing damage, a basic retention of title clause will be effective, but it's likely that there will be some argument about how easy removal is. Where goods have been irretrievably mixed, for example, chemicals in a compound or fabric in a garment or resin in chipboard, the basic clause will not be effective. In these circumstances, a mixed goods clause is often incorporated, enabling the seller to assert rights over the resulting product. However, the courts have held that such a clause does create a charge over the resulting products, which would be void against a liquidator or an administrator for want of registration. Where the court decides that a contractual term is void, it has the power to strike it from the contract. But a court can't strike out part of a contractual term, so it's all or nothing. So from a drafting perspective, and to avoid the risk of a basic ROT clause being struck out, it's advisable to include an all monies clause, a proceeds of sale clause, and a mixed goods clause in a separate clause from the basic ROT. If a buyer disposes of goods which are subject to a valid ROT, a third party who acts in good faith without notice of the ROT clause will acquire good title to the goods, and the seller in these circumstances will be left with a claim against the buyer for damages for breach of contract. And this would be an unsecured claim if the buyer then enters into a formal insolvency process. So what happens when the buyer enters a formal insolvency process? Well, the duty of a liquidator or an administrator is to maximize realizations for creditors. Therefore, a seller seeking to enforce an ROT clause should expect to be asked to provide detailed evidence in support of the claim in the form of contractual documents, evidence of incorporation of the ROT clause into the contract, invoice numbers, delivery notes, and to be asked to identify stock at the buyer's premises by reference to those documents. The moratorium, which comes into effect when a company enters administration, prevents a seller from enforcing its ROT clause without the consent of the administrator or the court. And remember, I talked earlier about the balancing exercise that the court will then have to undertake in the context of an application. An insolvency office holder, though, cannot deal with items that are subject to retention title because they don't belong to the company. If they do deal with those assets, they will be personally liable for damages for interference with goods. However, where an administrator wishes to trade the business while they seek a purchaser for the business and assets, they may need to deal with the ROT assets. So provided the administrators accept that the ROT clause is valid, there's usually a negotiation between the administrators, the seller, and any prospective purchaser of the assets. The administrator would usually agree to pay for any goods that he uses, such costs being treated as an expense of the administration. And agreement is usually reached with the prospective purchaser regarding any remaining goods and sums outstanding. And it's often in the commercial interest of the seller to come to an accommodation with the prospective purchaser in order to foster a future trading relationship with a new customer. So finally, I'm just going to come on to look at some relatively recent provisions which were introduced in 2020 to protect essential supplies. In administrations and CVAs, a company may wish to continue to trade during the insolvency procedure, and its access to the continuation of supplies will be critical, but may be affected by the contractual rights of a counterparty to terminate contractual supply arrangements by the operation of termination clauses. The ability of a supplier to rely on termination rights in such circumstances is regulated by the provisions of the Insolvency Act 1986, which were expanded by the Corporate Insolvency and Governance Act 2020, which is known as SIGA. The Insolvency Act sought to protect contracts for the supply of essential supplies, which were then defined as gas, electricity, water, communications, etc., when a company had gone into administration or CVA. However, these provisions didn't protect supplies of other goods or services, which might be equally critical to a company's business. That position changed in 2020, with further provisions being introduced into the Insolvency Act by SIGA, which apply to all contracts for the supply of goods and services, subject only to certain regulated exceptions. And these provisions are triggered if a company enters into an insolvency process, such as administration, liquidation, or a CVA. Broadly, the protection works by preventing a supplier from ceasing to supply a customer purely because the company has entered into an insolvency process. Section 233B of the Insolvency Act 86 now renders inoperable any contract term that provides for the automatic termination of a supply contract, or which allows the supplier to exercise a discretion to terminate, or any other contractual consequence that is triggered purely by the customer entering into an insolvency process. For example, it will prevent a supplier from exercising a right to vary a contract that's triggered by the customer going into an insolvency process. If a breach of contract occurs prior to the commencement of the insolvency process, but no action is taken at that point, Section 233B prevents termination occurring post-commencement in reliance upon that breach. However, where a company continues to trade post-commencement, so in a CVA or a trading administration, and a breach subsequently occurs, the supplier may terminate, because in this scenario, termination is a result of a breach of contract and not the commencement of the insolvency process. So what is prevented is termination or variation because the company has entered into the insolvency process. Where suppliers continue post-commencement in a trading administration, the administrator must pay for all goods or services supplied at his request as an expense of the administration. So that concludes everything that I was going to speak about. And as Caroline mentioned, we will have a look at questions at the end of the session. But I'm now going to hand back to Caroline. Thanks, Caroline.
Thank you, Liz. Okay, so turning now to the different types of creditors within an insolvency situation, for example. What you'll see on this slide then is that I have categorized the different types of creditors that are at play into 5 different categories. The first one being parties with proprietary claims to assets held by an insolvent company. And what's important to bear in mind is that the entry of a company into a formal insolvency process does not defeat a proprietary interest of a third party and assets held by the company. So, as Liz has already mentioned in relation to ROT claims, the contract terms between the company and a counterparty may, for example, operate so that possession of an asset transfers to from the counterparty to the company, but the beneficial interest in the asset remains with the counterparty. And examples of that are hire purchase agreements and supply contracts, which contain retention of title provisions. And where you can show that you, rather than the insolvent company, has beneficial title to an asset, you're entitled to have it transferred to yourself. So this is why it's really important at the start of an insolvency process to dig out your retention of title claims, review them, and to inform an insolvency practitioner right at the beginning of a process if you believe that you have the benefit of ROT. There are specific forms that an insolvency practitioner will ask you to complete, and again, it's important that you do so early on in any process. You've then got secured creditors with fixed charges. And a creditor with a valid fixed charge over a company's assets is entitled to have the proceeds of realization of that asset to the satisfaction of the liability due to it from the company. What's important to bear in mind is that a valid fixed charge holder should suffer no deductions in an insolvency process from the realization of property secured by its fixed charge, other than when there are other prior ranking fixed charge holders over the same property, or the charge holder agrees that the disposal costs, for example, those costs that have been incurred by the liquidator or administrator, may be taken from them. You've then got secured creditors with floating charges, and a floating charge automatically crystallizes on the insolvency date if the holder of the floating charge has not already caused it to crystallize beforehand. Generally, on crystallization, a floating charge converts from being a generic charge over a class of assets to a fixed charge over specific assets of that class. And what insolvency legislation does, it accords priority, and that's in terms of distributions, to a charge based on its status on creation. So the later crystallization of the charge, which was created as a floating charge and it's crystallized into a fixed charge, will not prevent the charge from being treated as a floating charge for the purpose of determining the order of distribution in an insolvency process. You've then got what's called preferential creditors, and these are claims of some unsecured creditors that are given preferential status in the distribution of an insolvent company's realizations. And there are two preferential creditors that I've listed out here. You've got ordinary preferential claims and you've got secondary preferential claims, debts. Ordinary preferential debts are debts which are typically owed in relation to contributions to occupational and state pension schemes. It's also in relation to wages and salaries of employees for work done in the 4 months before an insolvency date, up to a maximum of £800 per person. And there is also certain holiday pay that is categorised as ordinary preferential debts. With regard to secondary preferential debts, on the 1st of January 2015, a new class of preferential debt was introduced, and these rank equally among themselves after ordinary preferential debts. The secondary preferential debts that were then introduced in January 15 consisted of certain deposits owed to depositors that weren't otherwise covered by the Financial Services Compensation Scheme. But what we have seen since then is the more controversial reintroduction of what was known as Crown Preference. And this affects insolvencies commencing on or after the 1st of December 2020. And HMRC now has secondary preferential creditor status in respect to certain tax debts. And they are in respect of certain VAT, PAYE, debts. There's also certain debts owed in relation to construction industry scheme deductions, employee national insurance contributions, and student loan repayments. So it's important to bear in mind that there is this secondary preferential status now at play. You've then got finally unsecured creditors. And as the title suggests, an unsecured creditor is one that does not have security over any of the insolvent company assets in relation to a debt that's due to it. And in order to participate in an insolvency process, an unsecured creditor must have a provable debt. To be a provable debt, what I've put within this slide here is that it must fulfill one of these three criteria. So the company must have been subject to the debt or liability when it entered the relevant insolvency process. The debt or liability arises from an obligation to which the company was subject when it entered the relevant insolvency process. Or the debt or liability is to interest which accrued before the insolvency and is provable under Rule 14.23 of the Insolvency Rules. Now, unsecured creditors' claims generally are paid pari passu, which means that an unsecured creditor may receive interim and/or final dividends paid pro rata, and that's during and/or at the end of an insolvency process. So it is generally quite questionable whether or to what extent unsecured creditors do receive returns in an insolvency process, and it's something that needs to be looked into if you're an unsecured creditor, again early on in in an insolvency process. And the reason for that is because we then need to turn to order of priority. So how are debts paid by reference to the categories of claims that are recognised in the Insolvency Act and insolvency rules? So, in broad terms, what I've put within this slide is the order of priority of creditors in an administration or insolvent liquidation. So, as you would expect, the first category to be paid out are holders of fixed charges. So, if an IP realises assets that are subject to a charge which is and was created as a fixed charge, the IP is required to distribute the realizations of those assets to the holders of the fixed charge security, and that's in order of the priority of their charges. Now, I've already mentioned that the holder of a valid fixed charge shouldn't suffer deductions from an insolvency process. So, what that means is if an insolvency practitioner intends to be paid in some way from the realization of fixed charge assets, then they will need to come to some sort of agreement with the fixed charge holder before that happens. And insolvency practitioners are very likely to be reluctant to realize fixed charge assets unless such agreement is reached. You've then got second in line moratorium debts and priority pre moratorium debts. Now, this is one of the categories of additional processes that Liz mentioned were recently introduced, and it's outside the scope of this talk, but it's just to bear in mind that there is this level of debt that comes out after fixed charge holders. Whether or to what extent it's relevant in any process would need to be examined. The next the next debts or level of debts that are paid are the expenses of the relevant insolvency process. And this includes the professional fees of the insolvency practitioner and those rendered by third parties to the IP in the course of their appointment. So, such things as any experts that might have been appointed, agents, legal costs. You've then got preferential creditors, and I've already touched upon the two categories of preferential creditors um, that are then paid out next. You've then got what's called the prescribed part. And this involves before an insolvency practitioner can distribute asset realizations to holders of floating charges, an IP is required to carve out what's called the prescribed part, which is used for distribution to unsecured creditors. Now, Parliament's intention behind enacting the provisions governing prescribed part was to try and improve the typical return to unsecured creditors from a corporate insolvency process. You'll all be familiar that it's common practice for a company to grant fixed and floating charge security over all assets and undertakings. And often the assets of an insolvent company, particularly when they're realized in the context of a formal insolvency process, are insufficient to satisfy the claims of secured creditors. So that then means that without the effect of the prescribed part, in many cases, unsecured creditors of an insolvent company wouldn't receive any return on a debt due to them. The prescribed part is calculated as a percentage of the value of the company's property, which is subject to a floating charge. So it's 50% of the first £10,000 of net floating charge realizations, plus 20% of anything after that. And that's subject to a cap of the amount payable of £800,000. You've then got the holders of floating charges. So once the IP's paid the expenses of the insolvency process and everything else that ranked ahead of it, they will then pay out to floating charge holders. You've then got unsecured creditors, and they are paid out from a combination of any remaining asset realizations and the prescribed part. Now, there is an eighth category, but it's very unusual. Very, very unusual in an insolvent situation, which is shareholders. So, after unsecured creditors are paid in full, any remaining funds belonging to the shareholders would then be paid. But very unusual to receive anything in an insolvency process other than a solvent liquidation. So, a liquidation called a members' voluntary liquidation, which Liz mentioned during her talk. So, when an insolvency process is instigated, what does that mean for creditors? Now, the commencement of an insolvency process will have implications for creditors and their ability to take any further action against a company. And that's why it's really important for suppliers and the like to have tight credit terms and credit control processes in place and to ensure that credit terms are not deviated from. Because once a company goes into an insolvency process, the ability to then take action will be severely restricted. So, turning first to administration, Liz has already mentioned the moratorium. Because of the moratorium, creditors are prevented from instigating or continuing any legal process against a company or property of a company without the permission of the court or the administrators. Compulsory liquidation. So, this is when it's instigated by the issuing of a winding up petition. And once a winding up petition has been presented, there's no automatic stay of proceedings whilst the petition is in, but the order has not yet been made. But the company or the creditor can apply to the court for a stay. Once the winding up order has been made, a creditor is prevented from commencing with or proceeding with any action against a company or its property, but a creditor may take permission to take action. With creditors' voluntary liquidation, that whilst there isn't an automatic stay, the court may order that any particular proceedings are stayed under its general discretionary power, and that's under Section 1121 of the Insolvency Act. And with company voluntary arrangements, that situation very much depends on the terms of the CVA document. And that's why it's really important to read and understand the terms of the CVA and the rights of creditors going forward. Because once a CVA has been is been implemented, so effectively agreed and is in place by by creditors, it binds all unsecured creditors. Now, a CVA cannot affect the right of a secured creditor to enforce its security except with its consent. Secure creditors don't generally vote on a CVA, save to the extent that their debt is unsecured. And that effectively means that a debt owed to a secured creditor cannot be compromised by a CVA, but is generally dealt with by direct negotiation or paid in full. So I'm now just going to touch upon directors' duties. And this is important for anybody advising directors in a situation where there are concerns over a company's solvency or its sort of financial standing. The Companies Act codifies most, but not all, of the duties imposed on directors by case law and equitable principles. There are 7 statutory duties, and I've listed each of these statutory duties and the relevant section number of the Companies Act within this slide. What's important to bear in mind is that ordinarily a director is under a duty to act in the best interests of the company and its shareholders. But that situation changes when a company is financially distressed and formal insolvency proceedings become more likely. The director's duty in that situation is to promote the company's success pursuant to Companies Act 1721 is modified by the company law rule that the company's interest is to be taken to include the interest of the company's creditors as a whole. So there is a shift between what the director's duties are at during that time. The period in which the director's duties shift from being primarily owed to the shareholders to the creditors is commonly referred to as the twilight zone. And that zone may be long or short depending on the particular circumstances. The Supreme Court in Sequana considered when the twilight zone considered the twilight zone and when directors should consider the creditor's interests. And it held that when the directors know or ought to know that the company is insolvent or bordering on insolvency, or that an insolvent liquidation or administration is probable, they must consider the interests of the creditors, balancing them against the interest of the shareholders where they conflict. And that's known as the creditor duty. And what that means is that it is in effect a sliding scale. So the greater the company's financial difficulties, the more the directors should prioritize the interests of creditors. Where an insolvent liquidation or administration is inevitable, creditors' interests become paramount. And the court confirmed that the relevant interests of creditors for this purpose are the interests of the creditors as a general body. The directors are not required to consider the interests of particular creditors in a special position. And where the directors are under a duty to act in good faith in the interests of creditors, the shareholders cannot authorize or ratify a transaction that is in breach of that duty. Now, in 2023, there was a recent case of Hunt and Singh, and this avoided a tax avoidance claim. And there was a question raised, a principal question raised on appeal, that following Sequana, was a director's duty to take into account sorry, the question was whether a director's duty to take into account the interests of creditors arises where the company is at the relevant time insolvent, but its insolvency is due to a tax liability which the directors believed at the time had been avoided by a valid tax avoidance scheme entered into by the company. And what the court held in that case is that where a company is faced with a claim to its current liability of a size that its solvency depends on challenging that claim, then the creditor duty arises if the directors know or ought to know that there is at least a real prospect of the challenge failing. So, what this all means, generally speaking, is that seeking prompt specialist advice from an insolvency professional, keeping detailed records of decisions will go a long way towards showing that a director has considered and acted in accordance with their statutory duties. However, directors are still required to exercise independent judgment and cannot simply defer to advice provided by professional advisors. So, to recap, when a company is solvent, then broadly speaking, its interests and that of its directors are aligned. The position then changes as a company nears a point of insolvency, as the directors start to owe their duties towards the company's creditors as a whole rather than the company's members. At that stage, any director seeking legal advice on their position should do so with independent solicitors rather than the company's own solicitors to avoid issues arising later on. And where there's no prospect of avoiding an insolvent liquidation or insolvent administration, the director's duties is to manage the affairs of the company with a view to minimizing potential losses to creditors from the company's position. Now, if in due course a company goes into um, an insolvency process, such as liquidation or administration, then what will happen is that the insolvency practitioner appointed to manage the company's affairs will usually investigate the circumstances in which the company became insolvent. And that investigation will typically include, as I've said within this slide, the conduct of directors and the decisions that they took with regard to the management of the company's affairs, and the transactions entered into by the company in the lead up to its insolvency. And then you've got the investigation that will then be conducted by the insolvency practitioner. And that will typically encompass the following grounds that I have highlighted within this slide. And you've got wrongful trading, fraudulent trading, misfeasance, breach of duty, transactions at undervalue, preferences, extortionate credit transactions, and transactions defrauding creditors. That means that if there are any concerns raised by directors of a company concerning its financial position, then they are always well advised to seek independent professional advice from insolvency professionals and solicitors at the earliest opportunity. And in the meantime, to keep detailed records and up to date records, and to generally keep matters under constant review. So, finally, what I'm going to talk about are some of the statistics that we have seen from last year and what we're looking at this year. Because against everything that Liz and I have spoken about, and with emphasis on ensuring that we're alive to the current economic climate and what it might mean for businesses, I think it's important to touch upon insolvency statistics flowing from last year and what we're currently seeing this year in terms of corporate insolvency numbers. So, what did we see last year, the annual for 2024? What we saw were 23,872 registered company insolvencies. And I've put out down within this slide what these consisted of, and you can see the huge amount of creditors' voluntary liquidations. Now, the total number was slightly lower than 2023. It was down by 5%. And that was driven mainly by CVLs. And you can see that within this slide because also we've got the slight dip here in creditor voluntary liquidations, which caused this dip in the total insolvencies. But the number of compulsory liquidations actually increased by 14% from 2023. And that was, in fact, at its highest number since 2014. Administrations were also up by 2%, and CVAs were up by 9%. This slide is actually quite helpful in quantifying. So, this gives us again total number of insolvencies. And what we can see here is you can see 2020, 2021, which is obviously our COVID years. And the government put in place a lot of restrictive measures during that time to prevent the huge swathe of insolvencies that would have otherwise occurred during that time. So we see the drop off in insolvencies, and then we see the increase that has happened subsequent to that. Slight drop off in 2024, but certainly a huge increase since this 2014, where this table starts from. And this table then shows the historical trend of company insolvency since January 2020. And what you can see is you can see the peak here in 2008, 2009 recession. So the large numbers of insolvencies that happened during the 2008, 2000 recession. And then we see a decline and then the huge drop off in 2020 as a result of the COVID measures. And then we can see this incline up to what we can see is almost at a level of the numbers that we saw during the recession, 2008, 2009 recession. And then by industry, because this is always interesting to see which industries were most impacted last year. And there will be names, groups within here that I'm sure that won't come as a huge surprise given what was within the press last year about corporate insolvencies. So the five industries that experienced the highest number of insolvencies in 2024, we've got construction, wholesale and retail, trade, accommodation and food service activities, administrative and support service activities, and manufacturing. And I've given the percentages here of cases within those industries that were captured. What are we now seeing coming into this year? So, we know for January 2025 that there was recorded 1,971 corporate insolvencies, and that's in fact 6% higher than in December 2024 and 11% higher than what we saw in January 2024. Again, I've categorized these into compulsory CVLs, administration CVAs, so you can see the numbers flowing from that. We can see that CVLs actually accounted for 78% of all company insolvencies, and that's an increase of 9% from December 2024. Turning quickly, because I'm mindful of time, February, again, we're seeing a slight increase. So we saw 3% higher in numbers than January 2025. And again, I've put within this slide, and you'll get copies of these slides, of what the November corporate insolvencies consisted of. Interestingly, there were no receivership appointments. Compulsory liquidations were higher than in January 2025, while CVLs, administrations, and CVAs were slightly lower. Compulsory liquidations in 2025, we can see this increase here, was the highest monthly since September 2014. So, what are we likely to see continuing in 2025? The statistics show that company insolvencies remain at very high levels and close to the levels that we saw during the 2008-2009 recession. Significant challenges remain for businesses in 2025, particularly for small to medium-sized businesses, many of whom rely on shareholder and lender support to remain solvent. Measures introduced by the government budget in November 2024, and those including national insurance, national minimum wage, reduction to business rates relief, those are all going to put further strain on businesses, particularly small to medium sized businesses. The outlook for trade is expected to remain challenging due to trade barriers with the EU, conflicts in Europe and the Middle East, and of course, the uncertainty and threats of tariffs that are coming from the USA. We've also seen the restored appetite of creditors, and that's especially HMRC, to pursue debts more aggressively. And that is undoubtedly going to add pressure for businesses. And we are seeing an increase, as we've seen in the numbers, of compulsory petitions. Many are predicting insolvency levels to remain at current levels. Some are forecasting that it may increase by as much as 10%, and that would put us on a par with those levels seen in the 2008-2009 financial crisis. PwC recently commented on the 2005 insolvency numbers and said that the cost of debt remains persistently high, significantly reducing the cash available for investment and other essential business activities, and consumer sentiment has struggled to recover. We are witnessing a trend that many failing businesses are mature, well established companies. And PwC analysis indicates that over 80% of businesses have been trading for more than 5 years, and those that are going under. They are then quoted as saying, our analysis highlights that the construction sector in particular continues to face severe challenges, with over 400 construction related businesses failing during February. High input costs, both in raw materials and labour, and the inability to fully pass these cost increases to consumers means tight margins are being further squeezed, leaving businesses in a difficult position. And that is certainly something that we are seeing. And it is against that backdrop that it's important for business directors and advisors to keep a close eye on financial concerns that may arise at any given time for a business, and to understand the importance of taking advice from the right professionals early and not to delay matters. So that very much concludes our talk. I appreciate we're almost 10 minutes over time. So what I would suggest is that if anybody has any questions for us, that they please email us. We have just put our contact details up on the slide. Please do take a note of those. Contact us with any questions that that may have arisen during this talk, or anything that you'd like to talk to us about. More than happy to do that with you. Um, Otherwise, I wish you a very pleasant rest of your day and hope to see you again soon. Bye bye.
Right.